Hi guys, it's Kathy. I hope you're doing well. Alright, this is where we left off last night. The same moment we stopped last night. Alright. So we're gonna try to finish Judge Fish this morning. I feel good about this morning. I think this morning's gonna go very well. I think yesterday was just readjusting. Alright. Let's keep going. Here we go.
Judge, I literally just talked to him on Friday. He said he would be here today. He is not currently here. We would be asking for a short date. If we can hold any bench warrant under advisement, I will make sure that he is produced and comes to court. I don't think he's failed to appear before either.
No, he has not.
And we are close on an agreement, by the way, also.
Are you here next week?
I will be actually out of town next week, Judge. And Judge, he does live in Minnesota. I don't know if he's on Zoom possibly.
Guys, it's perfect. It hasn't budged. It hasn't budged. The internet has been rock solid steady for 2 minutes now. Alright, guys, that's what we get Monday morning. We get this. This is wonderful.
No, he's not. No.
Hmm.
When are you here next?
Judge, I can be here in 2 weeks.
I don't see you on the calendar. I'll set it up for July the 20th. You can appear by Zoom. Your client can appear by Zoom. And if he fails to appear that day, I'm going to issue a bench warrant.
Absolutely.
I'll hold a bench warrant under advisement from today's hearing.
Thank you.
And I was looking for you, not Mr. Murray, but I see that now for Tremel Newman. State, would you please set a record?
Yes, this will be
10.
State of Indiana versus Tremel Newman, 64 D01, 2503 F4, 2930. Defendant appears with counsel. Attorney O'Donnell, states represented by Deputy Prosecutor Hammer. We were set today for a status.
Judge, on this matter, we do intend to get this resolved. We can potentially get that September 14th date. I am confident that we can have it resolved with a change of plea on that day.
Any objection, State?
No, Your Honor, just that probably after that, we need to get it on the trial calendar.
Yeah, I was going to mention this is going to be the last opportunity for that. September the 15th, you said?
September 14th.
Yep, I see it. Sir, your attorney's asked for a continuance to September the 14th. I'll grant that. Continue it on defense motion. Charge related to the defendant. Have you back here on September the 14th at 10 a.m. You're ordered to appear. Do you have any questions?
No.
V. Hey, V. I got my internet fixed before you got your air conditioner fixed, and that's not right because it is hot. 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 When are you going to have air conditioning? When?
Okay, we're adjourned. Thank you.
I think I'm going to sneak downstairs. Yesterday at the festival, I bought some kind of blueberry loaf. It's a blueberry loaf. I don't know. I have no idea what it is, but I can find out if I go downstairs and get a piece. So I think I'm gonna go downstairs and get a piece of that real quick. I'll be right back. Look, the internet is not budging. It hasn't budged at all, so it should be perfectly fine.
And Judge, real quick, what was the new date on Wheeler? No, it was July.
20.
On Wheeler, July the 20th at 10.
Perfect. Thank you.
Yes, sir.
Have a good day.
And Zoom, like I said, is fine.
Thanks.
All right, Mr. Peters, you've been patiently waiting. Nicholas Abduchan, State, would you please set a record?
This will be State of Indiana versus Nicholas Abduchan, 64 D01, 2509 CM 10725, and 64 D01, 2410 F4 10209. Defendant appears by video at the Porter County Jail and is represented by counsel Attorney Peters in the courtroom. State's represented by Deputy Prosecutor Hammer. We were set as a status.
May I approach?
Yes, sir. Thank you. Mr. Abushan, I've got a one-page document here entitled Waiver of Administrative Rule 14 for personal court appearance, which appears to bear your signature. Did you sign this?
Yes, Your Honor.
Did you understand you're waiving your right to appear personally here in court today? You're appearing by video instead?
Yes, Your Honor.
Any objection to the video appearance, State?
No.
What's that? Mr. Abushan, for purposes of the change of plea, please raise your right hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Sir, please state your full name for the record.
Nicholas Stephen Abushan.
Have you ever gone by any other name?
No.
How old are you?
30 years old.
The court has been informed that you wish to change your plea to guilty in CM 10725, count 1, trespass. Well, excuse me, I read that wrong. This says that you're going to enter a plea of guilty, yes, in CM 10725, count 1, trespass, a Class A misdemeanor, and then you're going to admit to some probation revocation matters in F4 10209. Is that correct?
Yes, Your Honor.
Okay, I'll go through the change of plea first. Before I can accept any guilty plea, I need to ask you some questions. At any time you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
No.
Are you currently under the influence of any alcohol or drugs?
No.
In CM 10725, count 1, trespass, a Class A misdemeanor, how do you now plead?
Guilty.
Mr. Abushan, you have the right to a public and speedy trial by jury. Do you understand that?
Yes, Your Honor.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes, Your Honor.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes, Your Honor.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes, Your Honor.
You cannot be forced to make any statement or to testify against yourself in any hearing or trial, but have the right to remain silent. Did you understand that?
Yes, Your Honor.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
Yes.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes, Your Honor.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court will appoint one for you. Do you understand that?
Yes, Your Honor.
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. Do you understand that?
Yes, Your Honor.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes, Your Honor.
If you're not a citizen of the United States, the conviction of these charges may change your immigration status. You might either be in a less favorable immigration status or projected to being deported from the United States. Do you believe that'll be a problem for you in this case?
No, Your Honor.
Possible penalty for a Class A misdemeanor is up to a year in jail and up to a $5,000 fine. You understand that possible penalty?
Yes, Your Honor.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
Yes, Your Honor.
Other than in this court, are you on parole or probation anywhere?
No.
Are you out on bond on any charges anywhere?
No.
This plea of guilty may cause harsher sentences for any future crimes. Do you understand that?
Yes.
Court received a 5-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature. Right at the bottom of the 4th page, did you sign this agreement?
Yes, Your Honor.
Did you read it before you signed it?
Yes, I did.
Did you have a chance to speak with your attorney before you signed it?
Yes, I did.
Before you signed this, do you believe you understood its contents completely?
I did, Your Honor.
As I understand the sentencing portion on the agreement, in CM 10725, count 1, you'll be sentenced to, must be 60 days in the Porter County Jail with none suspended, credit from February 24th, 2026 through March 26th, 2026, and you've got time served on that. So there's no time for him to do any other terms, so that must be related to the probation revocation. Is that fair, counsel?
The rest of the time is going to go for the revocation.
All I'm going to do is caret in a TY above 6, so it's
Yes.
clearly 60,
And I had done that as well.
because numerically there was a 60 next to it. Is that your understanding of the disposition, sir?
Yes, Your Honor.
And I've told you you'll get credit for your time served awaiting disposition, correct?
Yes, Your Honor.
You understand I'm not a party to this agreement, but I'll be bound by its terms at your sentencing and with respect to any future sentence modification?
Yes, Your Honor.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No, Your Honor.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No, Your Honor.
Your attorney's going to ask you some questions on the trespass case only. Mr. Peters?
Certainly, Judge. Nicholas, on September 11th of 2025, you were in Porter County, Indiana, correct?
Yes.
And you were on the property of Randall Truck and Boot without permission, correct?
Yes.
And you had no contractual interest in that property, correct?
No.
And you interfered with their possession and use of that property, correct?
Yes.
No further questions, Judge. I'll stipulate to the probable cause affidavit for count 1 as it relates to the plea.
State
State would stipulate as well, Your Honor.
will admit the probable cause affidavit insofar as it applies to count 1. I don't have any additional questions. Court finds the defendant understands the nature of the charge against him to which he's pled guilty, that he understands the possible sentence for that charge, that his plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. We're moving into sentencing, State.
Yes, Your Honor.
Go ahead.
Given his history, I didn't think putting him back on probation was a good idea, at least for that case. So I ask that you accept the agreement based on that.
Mr. Peters.
Same.
Mr. Albertson, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right?
No, Your Honor.
That's fine. Court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction in CM 10725, count 1, trespass, a class A misdemeanor. Sends you to 60 days in the Porter County Jail with none suspended. Credit for your time served from February 24th, 2026 through March 26th, 2026. Fines, fees, and court costs all reduced to judgment.
Yes, Your Honor.
Reduce all your fine, fees, and court costs to judgment. Mr. Albertson, I've got the disposition here as part of this written agreement related to the F4 10209. You understand that what this says is you plan to admit to violating your probation, and then upon that admission, you'll be sentenced to 180 days in the Porter County Jail with none suspended. You'll get credit from March 27th through today. You'll return in complete probation as originally ordered. Undergo substance abuse treatment as a condition of probation. Be responsible for the payment of all associated fees. Sign all releases of information for court, probation, state, and council. Is that your understanding of the disposition?
Yes, Your Honor.
You realize if you admit your probation violation, you'll be waiving the right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation?
Yes, Your Honor.
You'll be waiving the right to confront and cross-examine witnesses and to use the court's subpoena powers to have witnesses brought here to testify on your behalf.
Yes, Your Honor.
With that in place, you'd still like to admit the violation of probation?
Yes, I would.
Looks like part of your admission is because of the conviction that we just did in short cause CM 10725. So you admit that you already admitted that you committed that crime, correct?
Yes, Your Honor.
And then this says you were in possession of illegal substances. Did you use drugs while you were on probation?
I did, Your Honor. Yes.
All right. And then you also had the arrest in Lake County. You're admitting that you were arrested for additional charges in Lake County, correct?
Yes, Your Honor.
Court will accept your admissions, finally you violated your probation, accept the recommended disposition, and sentence you in accordance with the terms of your agreement. Do you have any questions about anything?
No.
When you get out of jail, you should get out of jail today, actually.
Your Honor, he's got a couple more because it's 3/4, so he has to serve 135 active.
Oh, my bad.
What would be the day?
August 9th.
August what?
9th.
August 9th.
Okay.
My bad. I didn't mean to get you excited.
Thank
When you get
you.
out of jail, though, you need to go directly to the probation department and get reacquainted with Ms. Vukic, okay?
Yes, sir.
You have any questions?
No, I hope you guys have a great day.
Anything else, Mr. Peters, for the state of Indiana?
No.
All right, we're adjourned. Good day to you.
Thank you.
You have Byron Murphy?
Judge, I thought Mr. Pingle was set.
He also has
Custody.
I think Byron Murphy, is Byron Murphy in there?
No, he's here.
Oh, is he?
He's here. The one that I have in custody.
AJ Pingle, say, would you please set a record?
This will be State of Indiana versus AJ Pingle, 64D01-2604F14912. Defendant appears in custody by video at the Porter County Jail and is represented in the courtroom by Attorney Peters. State's represented by Deputy Prosecutor Hammer. We were set today for an omnibus with the pretrial on August 10th.
Yes, sir. Mr. Pingle, can you hear us okay?
Yes, Your Honor.
Mr. Peters?
Judge, I thought we were also set to address the motion to revoke his bond. I was here to request his release on his prior bond. He's been in jail now since May 20th or May 19th between Berrien County and here.
I granted the motion to revoke bond back on May 21st. So if you want to reinstate bond,
Oof. V, you know I'm up for a good challenge. I would actually do anything on a dare. But man, okay. Just trying to picture that first day. You laying on my sofa, telling me about your mama. My hair just turned gray thinking about it.
we'll have to have a written motion from you on it. Happy to set it over for next week.
Please do.
Okay. Now, Mr. Pingle, I'll set you over for Monday, May the 13th. You want to do it at 10 or 11?
Thank you, Your Honor.
Probably 11.
11? At 11 o'clock. I'll see you back here next Monday at 11 a.m. You're ordered to appear.
Thank you.
I saw a bunch of dudes in the hearing room still. I didn't know if Murphy was in there or not. He's an add-on. State Police had a record for Byron Murphy. Do you have it?
Yep. This will be State of Indiana versus Byron Murphy, 64D01-2501F5539. Defendant is present with counsel. Attorney Peters, State's represented by Deputy Prosecutor Hammer. We were set today for status.
Now approach.
Yes, sir. Okay, thank you. Mr. Murphy, for purposes of the change of plea, please raise your right hand to be sworn. Do you swear or affirm under penalty of perjury, tell the whole truth and nothing but the truth?
Yes.
Thank you, and please state your full name for the record.
Byron Murphy Jr.
Do you have a middle name, sir?
No, I do not.
Have you ever gone by any other name?
No.
How old are you?
47 years old.
The court has been informed that you wish to change your plea to guilty on an amended count 1 intimidation as a lesser included level 6 felony. Is that correct?
Yes, sir.
I need the code citation added to this plea. Before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
No.
Are you currently under the influence of any alcohol or drugs?
No, sir.
to the amended count one, intimidation, a lesser included level 6 felony, how do you now plead?
Guilty.
Mr. Murphy, you have the right to a public and speedy trial by jury. Do you understand that?
Yes.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes, I do.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes.
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Did you understand that?
Yes.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. You understand that?
Yes, I do.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes.
You have a code cite for me?
Yes, Your Honor, it's 354521B1A.
Sorry, Judge.
It's all right. 35-45-2-1, parents B, parents 1, parents A.
Correct.
All right. It's in there. I added it to the document. It doesn't change anything whatsoever. It's just very helpful for us administratively to have that in there. All right.
Mhm.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. Do you understand that? Mr. Hammer, please approach. I need you to sign this as well.
Yes.
Sorry, Judge. I typed it.
By pleading guilty, you're admitting that everything the state would have
Okay.
to prove beyond a reasonable doubt.
Okay. Now we see the prosecutor has a nice 70s stash on him. I think I've seen him in a couple of movies.
For you to be found guilty is in fact true. Do you understand that?
Yes.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes.
If you're not a citizen of the United States, conviction of these charges may change your immigration status. You might either be in a less favorable immigration status or subjected to being deported from the United States. Do you understand? Do you think that'll be a problem for you in this case?
No.
Okay. Possible penalty for a level 6 felony is from between 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. You understand that?
Yes.
Are you currently on parole or probation anywhere?
No.
Other than this case, are you out on bond on any charges?
Okay, I know I celebrated it like 2 minutes and 4 minutes, but it's been 23 minutes, and the internet is rock solid steady. I'm gonna try. No, I'm not. I was gonna try Twitch, but I'm not. I'm gonna try Twitch tomorrow. Don't let me forget. I'm going to forget. But I can't believe it. This is so nice. What happened last night, though? Okay, doesn't matter. Doesn't matter. This is really nice.
Anywhere.
No, sir.
All right, this plea guilty may cause harsher sentences for any future crimes. You understand that?
Yes, sir.
The court was presented with a
Same at this festival yesterday. There was this big bouncy. I don't know. It looked sort of like one of those things that actors fall in when they jump off buildings. All right, there was no walls on it or anything. I actually don't know how I would have gotten up on it. Now that I think about it, but it was you could go in there and you could bounce. There was no walls. I'm like, I can't go in there and bounce around. I get black eyes as soon as I got up in there.
a 4-page document entitled Recommendation of Plea Negotiation. The document, which is now in order, appears to bear your signature about 2/3 of the way down. On the 3rd page, did you sign this agreement?
Yes.
Did you read it before you signed it?
Yes.
Did you have a chance to speak with your attorney before you signed it?
Yes.
Before you signed this, do you believe you understood its contents completely?
Yes.
As I understand the sentencing portion of the agreement, you'll be sentenced to 540 days in the Porter County Jail with all but time served suspended. Does this say
Formal.
formal probation? You'll get credit for time served from January 5th through May the 6th. And I think that says 108 actual.
Correct.
Your Honor, I think that's 112. I just pulled up the Joe roster and it says it's 112 days.
Are the dates inclusive, correct?
Yes,
1/15/2025 through May 6, 2025?
yes.
I'm going to strike through 108. I'm going to white it out so there's plenty of room to write. 112,
Yes.
and I'm sure you have no objection to that.
None.
You'll get credit for your programming at the Porter County Jail and continue ongoing counseling. And you'll sign releases for the probation department. There's no restitution, but there's a no contact order that was entered as a condition of bond that will continue throughout the term of the sentence. Is that your understanding of the sentence?
Yes.
I believe you understand it?
Yes, I do.
You understand you'll get credit for your time served awaiting disposition of the case?
Yes.
You realize I'm not a party to this agreement, but if I choose to accept it, I'll be bound by its terms at your sentencing and with respect to any future sentence modification?
Yes.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No.
Your attorney's going to ask you some questions to establish the factual basis for your plea.
Thank
Mr.
you,
Peters?
Judge. Byron, on January 14th of 2025, you were in Porter County, Indiana, correct?
Yes.
At that time, you came in contact with an individual who's now your ex-wife, correct?
Yes.
And you communicated a threat to your now ex-wife, correct?
Yes.
And that threat was to commit a forcible felony, correct?
Yes.
No further questions, Judge. I'll stipulate to the probable cause affidavit as it relates to the amended count 1 intimidation as a level 6 lesser included felony.
Okay, State,
I'd join in that stipulation, Your Honor.
any further questions?
No, Your Honor.
All right, I don't have any additional questions. Court finds the defendant understands the nature of the charge against him to which he's pled guilty, that he understands the possible sentence for that charge, that his plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. The police says you're going to waive the pre-sentence investigation. That's still your intention now?
Yes, Your Honor.
All right, I'll show the waiver of the pre-sentence investigation and report. Anything for the sentencing?
Your Honor, just that the victim was contacted and made aware, and she is just more about treatment and all of that. So that's where
We sat with her when we did our notification.
So you notified the victim?
Yes,
And the victim responded that they're cool with this?
yes, yes.
All right. Anything else?
No.
Mr. Peters?
Nothing, Judge. Just asking that you accept it.
All right. Mr. Murphy, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right, sir?
Yes, I just want to say I'm sorry for, taking up the court's time with a situation that should never happen. That's it.
Okay. Thank you, Mr. Murphy. I mean, the court will accept your apology for its part. These are very serious matters, so you haven't wasted our time. I think that justice is important and that we need to invest the appropriate amount of time into it. But in any event, we'll accept your.
I'm glad that he said that. I'm glad he didn't just let that slide. He didn't apologize for his actions at all. He apologized for wasting the court's time, and the judge was like, oh no, this was serious, sir.
Apology for our part.
Thank
This
you.
time, the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on an amended count 1, intimidation as a lesser included level 6 felony. Dismiss count 2, sentence you to 540 days in the Porter County Jail, suspending all but time served to formal probation. Credit for time served from January 15, 2025 through May 6, 2025.
If I'm here, Monica's here. That's pretty much how it is. If it's playing, Monica's here. Monica, I love you.
That is 112 actual. You'll get credit for your programming at the Porter County Jail. Continue your ongoing counseling. We already did waive the PSI, and you'll sign all releases required for the probation department to monitor. There's no restitution. There's a no contact order that was entered as a condition of bond. Continue throughout the term of the sentence. You have that ready, State?
No, Your Honor, I will have to get that. That is one thing I don't have, so I'll have to get that filed, Your Honor.
All right. There was a cash bond posted in the case. From the cash bond, the court will retain court costs, probation, initial administration fee, jail booking, and sheriff's death benefit fee. The remainder goes where?
To a bail bondsman. I can't remember.
Well, this is a surety bond. I apologize. So we'll discharge the surety here. There wasn't.
I don't know, Kelly. I took off a lot of that time too. You know what I mean? I don't know. Okay, so I have a lot of people in my family that really are crazy. Crazy. My sister, my older sister, I don't talk about often, is absolutely crazy. My mom is psychotic. My other sister that I do talk about, she is also, she's not nearly as crazy as my older sister. My older sister is, you cannot have a conversation with my older sister. So my mom gets angry, and she does terrible things when she's angry, but you don't know when she's going to get angry. It triggers, I don't know what triggers it, but it just happens out of nowhere. All right. So what I do, so when I'm moving through life, when I feel that I'm about to get angry at something, I don't get angry at anything. I don't think I can get angry at anything, because I never ever want to be crazy. I never want to flip that switch and get crazy. So I don't ever, I mean, sometimes I get pissed off, but never really angry. Never. Because, you know, I don't want to be that. So that's how I regulate it. I'm like, okay, I don't want to be that, so I'll just sit here and chill and be happy.
A cash bond posted in the case at all. You're going to be responsible for your own court costs and things. It's a little bit less than $500. 6 months would be sufficient time for you to pay it?
Yes, I have a job.
Okay.
No, not at all, Kelly. So here's what happened. No, I'm not. Here's what happened. I had to get a different car. I had to buy a car while I was moving, because my little Mazda didn't make it. Just didn't make it. So I got this new Chevy Malibu. Not new, like new to me, Chevy Malibu. And I needed to get car insurance on it. So we pick up this Malibu. While we're driving home from the tag place where I bought the car, I said to my son, you know, I need you to bring that registration in to the house so that I can use that to get insurance. So then we stopped at my old house and to pick up some stuff, and then we drove that stuff to my new house. And my son did exactly what I asked him to do. He brought my car registration with my new address on it into the house at my last house, at my last address, and left it there. So I moved out. My registration with my new address was there, and nobody has come here. It's pretty far away, but my niece started texting me, and she's going, not my niece that I used to work with at Big Dog. This is a different niece. She's like, I don't know how to describe her situation, because you guys, you'll never believe me in a million years if I would tell you her situation. It's just so crazy. But she's in jail now, but she started texting me about how horrible my daughter is and how horrible my other niece is, her sister, that I used to work with at Big Dog. And I'm like, look, I do not want to block you. You're my niece, but you need to stop. You need help. You need to go get help. She was like, I did see a psychiatrist. He says I'm fine. I said, no, you're not. You're not fine. You need help. Well, she's in jail now because she was on probation, and my sister got her high and then called her probation officer on her. My sister's her mother. She was with my mother. So my sister and my mother got this little girl high who was on probation and then called her probation officer. So she's in jail now. She cannot come over and to my house, even though she was on house arrest. So, but she did come to my old house probably like a week before I moved out, maybe, even though she was on house arrest. So she comes over and she has this little ankle monitor on, and I'm like, aren't you on house arrest? How are you at my house right now? You're not allowed to be here. She says, oh no, it's okay. I called my probation officer and I asked permission to come and see you, Aunt Kathy, because you know the spirits told me that you were in trouble and you need me. I girl, I don't need you. I do not need her. There's no amount of trouble I could be in that could help me solve it. I said, are you high right now? And she's like, no, you can test me all you want. I'm not high right now. No, she was up on meth. She was so methed up she could not even finish the sentence. But she didn't drive over because she's not allowed to drive. Don't worry. Don't worry, she's not breaking the law that way. So anyway, she was texting me about how horrible her sister is and my daughter is. And then her mom gets her high, and her mom calls her PO, and she's in jail. And who does she reach out for? Her sister. She's like, I'm done with her. I'm done with that woman. I need help. Jessica, I need help. So my niece is like, no ma'am, I don't want no drugs in this house. So I don't know what's going to happen. I don't know what's going to happen with her. We're still in the middle of that great big mess. But all I know is I have to, I stay on top of every thought that goes through my head. I'm like my own little police. I'm like, okay, do not go crazy. Do not lose it today. I'm not saying that you can fix a severe mental disorder by thinking it away. I'm not saying that at all. I'm not saying that you should even try. I'm just telling you what I do with my life when I feel I'm about to snap. Although I do feel someday I am going to be on that TV show Snapped. I feel like that's in my future. Here we go.
Oh, okay. Just because you have a job doesn't mean you can afford to pay it. But
Yeah.
we'll give you 6 months to pay it. Let's see, what is all this?
That's not how jail works, V. When she goes to jail, when they go to jail, all they learn is how to commit crimes better. They get connections to sell bigger drugs, because they're in jail. So they all learn from each other's mistakes in jail. They all figure out how they got busted, and they all just, grow. And then they all trade each other's contact information so that when they get out, they have better drug dealers to deal with when they want to deal the drugs. And that's what jail is. Jail is like it's like a training center.
All right. I need you to go from here to the probation department, located at 157 Franklin Street, and get started on the terms of your probation. You know where they're located?
Yes.
All right. Good luck to you, sir.
Thank you.
Yeah, we're adjourned.
Thank you, Mr.
Head over to probation. Judge, I also have Mr. Gardner.
Yeah, Reginald Gardner, state would you please set a record?
State of Indiana versus Reginald Gardner, 64D01, 2605F2, 5474. Defendant appears with counsel attorney Peters, states represented by Deputy Prosecutor Hammer. We are set for omnibus.
Yes, sir.
Judge, I'm just entering on this. I'm sorry. Judge, I'm just entering on this case. I'm asking to roll the omnibus over to the pretrial on August 10th. Give me an opportunity to meet with the state and to resolve some issues with my client. I'm also asking that he be allowed to appear by Zoom. He did drive in today so that we could talk in person from Detroit. He was authorized to come by Zoom, but we needed to meet.
State, any objection to continuing the omnibus hearing to August the 10th?
No.
Okay, so on defense motion, we'll continue the omnibus hearing to August the 10th at 9 a.m. Mr. Gardner, you are from Detroit, Michigan?
Correct.
Okay, what's about 3-4 hour drive? All right, we'll allow you to appear by Zoom. You have a telephone or something where you can appear by Zoom? Have you ever used that application before? All right, we'll see you then on August.
Bobby, is Bobby here? I don't remember Bobby being here because he came last night. But Bobby's only 4 hours away from all the YouTube judges. He could go see Judge Simpson anytime he wants to. 4 hours isn't that far. He could wake up at 4 a.m. and he can drive. He can steal a car if he doesn't own one. Drive. Get a coffee while he's there. Okay. And he could see Judge Boyd. He better hurry up though, because it's almost time. It's almost time for the new judge to slide into her seat.
August the 10th at 9 a.m. You still want it at 9?
No, I would like it at 10, please.
Okay, I'll vacate the 9 a.m. setting and set it over for 10 a.m. local time here.
If Michigan was only 4 hours away from me, I would go see Judge Giles. That's the courtroom I would sit in all day, Judge Giles. I miss Judge Giles.
All right, on defense motion. We'll see you back here at that date and time. Do you have any questions about anything? Anything further, Mr. Peters,
No, sir.
for the state?
No, Your Honor.
Safe travel, sir. We're adjourned.
Thank you, Judge.
Thank you. Mr. Wood, you have a matter for Yusef Marega. State, would you please set a record?
This will be State of Indiana versus Yusuf Marega, 64D01, 2412 F5, 12431.
You are right. She is Texas. That's 27,000 hours.
Defendant appears with counsel attorney Wood, states represented by Deputy Prosecutor Hammer.
That's 27,000 hours after you get into Texas still left. Oh, but I don't have to encourage Bobby's bad behavior. He does that without me. But if he's going to do it, he might as well do what I tell him to do.
We're set today for, I believe, pretrial.
Yes, sir.
Yeah, if I may approach, we have a recommendation of plea negotiation.
Yes, sir. Thank you. Mr. Is it Marega? Am I pronouncing it correctly?
Yes, sir.
Okay, you're going to have to, speak into the mic. You guys are going to have to share that mic a little bit. So for purposes of the change of plea, please raise your right hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. Please state your full name for the record.
Yusuf Marega?
Do you have a middle name, sir?
No, sir.
Have you ever gone by any other name?
No, sir.
How old are you?
20.
Court has been informed that you wish to change your plea to guilty on count 2, possession of marijuana, a Class B misdemeanor. Is that correct?
Yes, sir.
Before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
I
No.
just noticed that. I don't know if you guys noticed. Probably not. But while he was talking, he stamped something with his stamper. And then we didn't hear a thing. I'm going to bounce back. Just a couple seconds. Oh, that's ahead. All right, here we go. I might not have gone far enough. Let me see. This, I definitely did. Okay, we're going to listen. We're going to listen to this stamper that doesn't make a freaking sound. Hold on.
How old are you?
20.
Court has been informed that you wish to change your plea to guilty on count 2, possession of marijuana, a Class B misdemeanor. Is that correct?
Yes, sir.
Before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'd be allowed to do that. Have you ever been treated for any
That was directly in front of the freaking microphone. His mouth isn't even as close to the microphone as his stamper was. And we didn't hear not one stamp go off. Every other courtroom we're at, ba-bam, ba-bam, ba-bam. Every single live stream. I love Judge Fish. He's such a great guy. He knows exactly what we want.
mental illness, or do you now suffer from any mental or emotional disability?
No.
Are you currently under the influence of any alcohol or drugs?
No.
To count 2, possession of marijuana, a Class B misdemeanor, how do you now plead?
Guilty.
Mr. Maregi, you have the right to a public and speedy trial by jury. Do you understand that?
Yes, sir.
You have the right to face all witnesses against you, see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes, sir.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
Yes.
You cannot be forced to make any statement or to testify against yourself in any hearing or trial, but have the right to remain silent. Do you understand that?
Yes.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. You understand that?
Yes.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. You understand that?
Yes.
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
Yes.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes.
Not a citizen of the United States, a conviction of these charges may change your immigration status. You might either be in a less favorable immigration status or subjected to being deported from the United States. You think that'll be a problem for you here?
No.
The possible penalty for a Class B misdemeanor is up to 6 months in jail and up to $1,000 fine. You understand that possible penalty?
Yes.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. You understand that?
Yes.
Are you currently on parole or probation anywhere?
No.
Other than this case, are you out on bond on any charges anywhere?
No.
This plea of guilty may cause harsher sentences for any future crimes. You understand that?
Yes.
Court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature halfway down on the 4th page. Did you sign this agreement?
Yes.
Did you read it before you signed it?
Yes.
Did you have a chance to speak with your attorney before you signed it?
Yes.
And before you signed this, do you believe you understood its contents completely?
Yes.
As I understand the sentencing portion of the agreement, count 1 would be dismissed. You'll be sentenced to 180 days in the Porter County Jail with credit for 3 days from December 2nd, 2024 through December 4th, 2024. You'll serve the balance on administrative probation, pay the related fees. Log everything back in from our reboot earlier. This is 64D022004 DN2898. Linda Pappas versus Nicholas Pappas. I have Tara Tauber here with the petitioner, Linda. We're set today on is it enforcing an order of some sort? Enforcing a settlement? What are we doing?
Judge,
Can you have the microphone, pull it towards yourself more?
yeah, can you hear me better?
Yeah, thank you.
Judge, just to give you some background on the case, there was an arbitration award in their dissolution matter. I believe at least it was accepted by this court in December of 2024.
So I think they lost internet and then crashed or something. I don't know. So that is why it switched real quick.
That was prior to my representation of Linda Pappas. That arbitration award provided a money judgment for equalization of the marital estate that my client was to be paid in the amount of $304,042.50. And so thereafter, I believe there were some proceedings. I think Linda Pappas's then counsel filed a petition for rule to show cause or citation or something. And so there was a hearing held, I believe, in March of 2025. There was some briefing. And then it was determined that because this was a money judgment, the appropriate vehicle to obtain funds for Ms. Pappas would be through a proceeding supplemental. At that point in time, or shortly thereafter, she changed counsel and I became involved in the case. We held a pro sup hearing, I believe, in July. Your Honor, I believe you were out and there was a pro tem. And really, Mr. Pappas indicated that he didn't have any money, he didn't have any funds to pay it, et cetera, et cetera. We then attempted to conduct some non-party discovery to see whether or not that was the case. And one of the places that we sent non-party subpoena to was Edward Jones, because Mr. Pappas at one time had not only an IRA there, but some other accounts. Apparently, Edward Jones then, because they received the non-party discovery, they froze, I guess, they internally froze Mr. Pappas's IRA. And so he filed a motion to release those IRA funds held by Edward Jones. And we filed an objection to that based upon the fact that we have discovered that Mr. Pappas has engaged in essentially a systematic attempt to hide his assets that we have discovered through our non-party discovery. And he's lied to the court under oath as to where his assets are. And so we believe that an equitable way to resolve this case wouldn't resolve it, but at least it would help, would be to, for the court to order that those IRA funds be quadroed to my client to at least somewhat give her an equitable resolution.
You need a quadro in an IRA?
Sometimes you do. Maybe Edward Jones wouldn't need one. I don't know. But I know I've had to do them in some cases.
Your Honor, could we increase the
Let's just
volume,
do
please?
Procedural posture from counsel here, so. Oh, you need a hearing assistance?
I have a severe hearing disorder.
Okay, we can help with that.
Thank you.
Do you think that's Judy? Is that Judy? I think her name is. We need to find out so that we know.
Okay,
Can you hear me?
yes.
Okay. You can turn the volume.
Can you hear us okay?
Yes, I can hear you, Your Honor. Can I make a statement?
In just a moment. But first, I want to find out whether you would like to present any evidence. Or is this just a hearing on turnover?
Well, it is Mr. Pappas's motion
Okay,
that we've objected to. So I think technically it would be.
Technically, ma'am, if it's Mr. Pappas's motion, your mouth shouldn't have been running. It wasn't your turn. Judge, come on.
Mr. Pappas.
I understand. So really, we're dealing with the February 25th, 2026 motion to release IRA funds and your objection.
Correct.
And that is subsequent to or on the heels of the frozen accounts. Are they still frozen?
Yes.
Okay, sir, please raise your hand to be sworn. Sit.
I have a broken back, I'm sorry.
You could have sat. Do you swear or affirm under penalty of perjury?
Nah, Judge. I always have to stand when my hand goes up. My hand goes up, my butt goes up. That's just the law.
To tell the whole truth and nothing but the truth.
Yes, sir.
Okay, thank you. You can testify from there as well. You see him okay? Okay. So, Mr. Pappas, I've got your motion. Did you want to present any evidence related to your motion?
Well, here's the latest summary from Edward Jones.
Okay. Did you want to have that marked and put into evidence?
Yes.
Okay. So I do need you to get up for that. Have you shared it with counsel? Stop by the table there, let her.
Judy, where were you? Judy, was that her name? We really have to figure it out. I'm going to keep calling her Judy until we figure out what her name was.
See it.
Where do I put?
Exactly,
You can put it
V.
around your neck, I think. Is it
Exactly.
big enough? Probably fairly cumbersome.
Yeah.
And then,
There's quite a bit that I think that the court and your honors should be made aware of.
well, sir, let's handle.
I don't think they stand anymore when the principal walks in the room. Eileen, I can't imagine the school principal walking into the room and not standing up. I just can't imagine it. I can't. Or when the priest walks into the room, you stand up. You don't just sit there and ignore them. And they always say, "Oh, sit down, sit down, sit down." But you at least attempt it. But I never had to stand up every time I spoke to my teacher. I didn't have to do that.
One thing at a time. I've got your document here. Ms. Tauber's had a chance to review it. Would you like to pose an objection at all? I know it's hearsay, but
No objection, Judge.
okay. So let's get that marked. If you could walk it over to my court reporter, she's happy to mark it for you. He is technically the respondent. He's the movant here, but we'll call it respondents 1. And then stop by me,
Wait,
and I'll
what?
take a copy
How can he be the movant and the respondent? What? All right, Margaret, have a good day.
of it, and you can have a seat back at the table, sir. Over here. Okay, go ahead and have a seat at the table. Your letter to me would most assuredly be hearsay, and it would be amplified by the fact that you're actually here and could just testify about whatever it is you would read to me from a letter. So go ahead and have a seat back at council table.
I assume your honor knows that my attorney withdrew from the case.
One housekeeping thing before you testify, sir, is that I will admit respondents exhibit number 1. It's admitted into evidence. What else would you like to say, sir? You can sit if you like. You can stand if you like. That's fine with me. And yes, I'm aware that your attorney withdrew.
Well, can you hear me?
I've got you fine.
Well, after $100,000 of retainers, I told,
All right. Sir, if you're going to lie, though, you ain't got $100,000. If you're going to lie, then this is a bad idea, sir. You're navigating into a minefield. You need to turn around. Abort mission, sir.
Mr. Rame, that enough's enough. I'm done paying this money. And the last 2 years, I hadn't talked to him but maybe 4 times because he had several surgeries. And when I told him I can't afford you anymore, when he told me, when I retained him, this may get up to $10,000. And through a mutual friend, the mutual friend told me that he would not be charging you any more money for this divorce proceedings. He denies this now. So I guess I must have made it up.
Objection, Your Honor, as to relevance.
Yeah, so you're into a realm that isn't really relevant to today's proceedings. What we're into from your motion is your request that the funds from your IRA be unfrozen and released.
Yes,
So
my
we're into
attorney,
This is a post-judgment question
yes, sir.
of proceeding supplemental to execution of the judgment.
Yes, sir.
But your former attorney has nothing to do with it, as far as I know. It would have no bearing on this question whatsoever.
Well, what do I do? Don't you take your attorney's advice? He told me they could not, many times, they could not take your IRA. Even O.J. Simpson was allowed to keep his retirement funds. And then when I went,
Sir, it is too soon to be speaking about OJ. We're trying to put that behind us right now. Will you stop? Triggered.
to remove it from Edward Jones, they said there was a block on it. That apparently counsel here must have had something to do with that. I don't know, because my attorney did not tell me. All I did was find out through my accountant that the IRA, I was not allowed to know how much was in there. I was not allowed to remove it, even though there's nothing in the paper that I've given the court that says that. And all the monies in that IRA were contributed before I met Mrs. Pappas 20-some years ago.
So I understand, sir. So it sounds to me like what you're doing is attempting to assert an exemption to execution of the IRA. I want to read your motion. When I hear what you're saying, what your lawyer advised you about really doesn't come into play, because the law is the law. What I have to do is look into the law a little further, I suppose. I've got the documents here which tell me this is a traditional IRA. The fact that the money was in there prior to your marriage has nothing to do with it at this point, because this is an asset that you own and there's a judgment against you. So anything that is an asset that is proper for execution is something they could seize and use towards the judgment.
Well,
So the question for me is whether or not an exemption applies.
yes, sir. Well, I have to prove when he withdrew from the case, he gave me 5 boxes of evidence that he never presented to the court.
Mhm.
And
There was no need to present evidence in your case, sir. It went to binding arbitration, and there was a ruling from an arbitrator on the case. And other parts of it were mediated.
these weren't presented to the mediator. There was 2 mediations, sir.
I recall, yes.
And the mediator, all she could do is say glowing things about my ex-wife.
I wish they would tell us how much money we're talking about here, but they're not saying.
Well,
And
sir,
I said, this is a joke.
well, sir, that has nothing to do with this either. So we're really trying to get down to the brass tacks of whether or not an exemption applies. Do you have any other evidence you want to present to the court about the status of the IRA or the possible exempt status of the IRA, anything of that nature, sir?
I was told that, well, if you don't like
Objection,
this
hearsay.
ruling by Mark
Coleman,
you could appeal, which I went through her office. She said there was
He went to the magistrate's office to appeal. I don't think that's legal, sir. I think that'll get you locked up. Thank you for the sparkles. Thank you, Eileen.
only one in Northwest Indiana. And Dubovich, I believe her name was. And she said, well, it's going to be $25,000 to appeal this case for 1 day of writing.
Yeah, I understand, sir. But again, it's irrelevant to the court whether or not you could have appealed and didn't appeal and how much that appeal might have cost you. You know, certainly I understand your plight, but it's just not something that has any bearing on this post-judgment proceeding supplemental to execution case that we're here considering today. So if you don't have any evidence related to the exemption, then I need to move on, all right?
What about evidence that was never presented that proves that my wife lied about some serious things during the trial?
This isn't the forum for that either, sir. So if you want to try to go back and undo the judgment somehow, you'll have to get a lawyer or figure out how to do that yourself. But all that we're here for today is proceeding supplemental to execution. So you understand procedurally where we're at. There's a judgment that's in place. It's my understanding it's for $304,042.50. That's what's called an equalization payment. That means that when the estate was determined by the arbitrator, they found that to make things equal, whatever the split was it a 50-50?
I believe it was.
Okay, well, there was a 50-50 split that it would take you to pay $304,042.50 back to Linda just so things were even as far as the distribution of the estate.
Sir.
But regardless of that, that judgment's final. Everything that happened leading up to that judgment is what we call merged into that judgment. And I can't revisit any of it, especially without a proper motion before me. So the only motion I have to consider today is you asking for your account to be unfrozen at the AG or at Edward Jones. And all I'm doing is suggesting to you that what you are asserting, I believe, is that it's exempt and can't be executed against. So if you don't have any evidence about it, I need to move on, sir. I only have a half hour dedicated to this hearing. We have another meeting at 4:00 with some other folks.
This wasn't mine. I did not approve of him doing this.
I'm not sure what you mean. I don't know who him is. I don't know what the thing is that you didn't approve of.
I wanted him to write a letter to Edward
Who's
Jones, my previous attorney.
Okay. So irrespective of what you wanted, that didn't happen. Things got to judgment. Everything that happened before is now merged into that judgment. Here we are at the proceeding supplemental to execution of that judgment, the post-judgment proceedings. And last time I'm going to ask you, do you have any evidence that you want to present related to the execution of this Edward Jones account?
So that's all we can deal with today.
So that's the only thing before me today.
I wrote a letter to you.
Okay.
I don't type, so I wrote it.
We just got a
I curse
letter. I bet, and I don't know why I think this, but I bet that letter was beautiful. I bet his handwriting is beautiful.
Okay, you're here. So if you want to tell me what's in that letter, I'm fine to listen to it if it's relevant to today's proceedings. But I'm not going to take a letter from you into evidence if it's not pertinent to the case today.
I still think I should create a YouTube video on how to write in cursive. I think that would go over big with the kiddos. And I said kiddos on purpose because I know people hate that word.
Which only deals with your exemption. We try to run a very tight ship here, Mr. Pappas. I'm sure you understand. We only have a certain amount of time to devote to every case. And in your situation, I've got 30 minutes. You've burned 20 of them already. I mean, we'll say that council spent 10. But I need to get to her to see if she needs to tell me anything or present any evidence of her own. Or
It sounds like if it was 50-50, it's like $600-some thousand. They're talking about $600-some thousand. Holy moly. You get an attorney for that. And no, you don't pay $100,000 for an attorney for that. No, you don't. But, anyway, I learned cursive. I guess I think it was in second grade as well. First grade was printing, and then second grade started cursive, and then everything after that was all cursive.
Or whether she has any questions for you right now, because you're under oath, and she's, I think, prepared to cross-examine you. Is that right, counsel?
Yes, Judge.
Okay. So have a seat, sir. She's going to
I
cross-examine you.
have evidence that proves that she perjured herself.
Doesn't matter to me today, because you have to file a motion with the court. I'm not going to tell you how to practice law. I'm going to advise you to hire a lawyer or consult with one if you believe that that's true. But you have remedies. Some of them are gone, but you have some that may still exist.
The money is gone.
I can't help you with that either, sir.
And I need money to live on. 25 years ago when I met her, I had a thriving veterinary practice.
Don't start with me, sir. 25 years ago, you had a thriving business. She had no opportunity to create a thriving business. If you guys had brats, she had to take care of them. So do not start with me, sir. You know what? I'm going to keep thinking about cursive. How did you guys learn cursive? The way I did is for homework every night, I had to write a letter like L, 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 L over and over and over again in my cursive notebooks. And then the next day I would have to bring it in and, here's all my R's, here's all my L's. And then the nuns would take their little red pen and they would circle all the L's that weren't pretty enough. And if there was too many circles, I had to do it all over again for homework the next day, plus the new letter. And we just kept doing that over and over again.
A national award. We got married, and she insisted on paying all the bills, which was fine with me. I put her name on all my assets.
Again, sir, nothing you're telling me right now is relevant in any way, shape, or form. It sounds like you may also try to argue that you've got a hardship, a significant hardship, and that because of that, I shouldn't execute on this Edward Jones account. But in any event, that's part of what I'll consider then when I'm considering your motion, okay? Whether there's a hardship that exists, but I need...
So my son does not have a girlfriend, does not. But there's a girl, okay? And they're both, you have to understand, they're both like 22. So going out to a bar is a new experience for them, and they enjoy it, like all 22-year-olds. So she owns a car. He does not own a car. When they go out to a bar, it's like agreed with them. My son gets the keys because this girl enjoys the bar. She walks in and how bars nowadays, they have like a list of these specialty drinks. All the bars have their own specialty drinks, and she's like, oh, I want to try that one. I want to try that one. I want to try that one. And I get it. I understand. So he almost 100% of the time drives home from the bars because he just doesn't drink that much. And he lets her drink as much as she wants, because she's 22 and they're out having fun. Now, I'm telling you this story because my son responded in a way that set me off yesterday, and we had a loud discussion. We had a loud discussion about just his reply to her when she said this, which he's like, I'm driving him to work, and he's like, Mom, this girl said something to me yesterday, which really, I was floored. I was flabbergasted. They're going to the beach this morning. They're going to drive to Ocean City, Maryland, which is about 5 hours away. Okay. You could probably get there in 4 hours, but every time I drive to Ocean City, I get lost. Mostly because I didn't have GPS every time I drove. Now we do, but so it takes me 6 hours to get to Ocean City, Maryland. So I'm going to say 5 hours, right? So the girl says to him, which right away unbelievably got me angry. The girl says to him, Anthony, do you mind if I drive the whole way to Ocean City, Maryland? Instantly, I'm upset. Like, what did she say? And he's upset. He's like, Mom, it's her car. She doesn't need to ask me if she's allowed to drive her car. I have no idea why she asked me that, but I was really upset that she asked me permission. He goes, yeah, when we go out to bars, I certainly don't let her drive, but that's because she drinks too much to drive, so I drive. But it's her car. I said, yeah, it's her car. You don't get an opinion on whether she drives or not. You don't get an opinion on that. You can't put your foot down. You don't have a foot because you don't own a car. She owns a car, right? Then I find out his response to her, and that's when the conversation got a little louder. It's nice when I get loud with my kids inside the car while I'm driving because it echoes, you know what I mean? Like, I really am loud. I'm not just loud. Like when you're in the house and you're screaming at your kid, it's loud. But when you're in the car and you're screaming at your kid, it's much more lovely. His response to this girl was not, it's your car and you can drive your car whenever you want to. I don't get an opinion on whether you drive your car or not because I don't own a car. His response was, well, I would prefer you drive the way home instead of the way there. What did you just say to her? You don't get to prefer when she drives her car. You don't get to prefer anything. You don't get an opinion. It doesn't matter what you would rather she do. Because you don't own a car, sir. So, anyway, they're on their way to Ocean City, Maryland right now, I think. Well, I don't know. I don't know if they're awake yet, but they should be. If I was going to Ocean City, Maryland, it's 5:49 a.m. I would have been on the road by now. I don't want to waste time. I don't want to waste today. That Ocean is calling their name. They need to go. I should call him and see if he's awake and on his way yet. I won't, though, because I don't care. You know, if he didn't make it in time, that's on him. But she does not want him as her boyfriend, though. And they both work together at the same place, and she doesn't want anybody at work know that they're spending time together. Yep. He is fully committed and in love with this little girl. And I was, too, at the beginning. But then she's like, I don't really want a boyfriend right now. But we can still hang out all the time. And they hang out all the time. So they go to, he tells me, Mom, I'm going to the beach with her. I said, you know what, that's fine. You can go. He wasn't asking my permission. I'm like, go to the beach with her. That's fine. But just remember, it's fine for you to pay for a girlfriend's trip to the Ocean City, Maryland. But it's not okay for you to purchase a friend's trip to Ocean City, Maryland. We don't buy friends trips to Ocean City, Maryland. Two adults that are friends that go on a vacation together, that's perfectly normal, but each pays their own way. Now this boy needs a car badly. I need him to get a car badly because I can't keep driving 3 people to work every day. It's so hard. It's every day. We all work at different times, and every day it's different times, and every day I have to figure out. So he needs to get a car. So he actually cannot afford to purchase her beach vacation. But okay, Hedwig, every single time I went to Ocean City, Maryland, I always got a campsite and pitched a tent and stayed there for a couple days in the tent. And except for the mosquitoes, it was lovely. They have these campsites now where there's like water slides at the front and camp stores where you can buy stuff, and they have activities in the campground like ice cream night and movie night and things like that. But I do remember, I don't know if, do they still have the toilets in Ocean City, Maryland, where you had to put a dime in to open the door? If you had to go to the bathroom. I don't know, Hedwig. I don't know. If I bought a car, and she has a really nice car. It's a Lexus. She didn't purchase her aunt owned a Lexus. Her aunt wanted a better Lexus. So her aunt sold this Lexus to her. Now, she still paid a good amount. She paid like $8,000 for it, which is not close to the price of a Lexus, but it's still, for a 22-year-old, a good amount of money to pay for a car. But if I had a Lexus that I purchased, nobody would drive it. I remember at her age, I owned a Mustang that I purchased and I worked on. I rebuilt it, and nobody drove my Mustang. My boyfriend back then, he also had a Mustang, and I was never ever allowed to drive that Mustang ever, until one day I got to drive the Mustang one day, and I got to drive it fast too, because we went swimming at a swimming pool. And we always went swimming, but he would never go off the diving board. He didn't want to go off the diving board. He never did. Until one day I talked him into it. I'm like, come on, it's the low dive. Just jump in and swim to the edge. You're fine. You got this. It's fun. I don't know what he did, but he dislocated his shoulder when he hit the water. So I got to drive the Mustang. I got to drive him to the hospital fast. Oh my. Anyway, yes, they're just they got a B&B. No, they didn't. They got a hotel at like $300 a night. So I think they're only spending one night in Ocean City, Maryland, tonight, and then he'll be back home tomorrow sometime, which is good because the grass needs cut. So we have this Roku, not Roku, what's the other, Ryobi? Did I say that right? We have a lawnmower, the bright green ones, you know what I'm talking about? And it's battery, it's not gas, it's battery. And we have 2 batteries. And our yard is so huge now that 2 batteries does like maybe 10% of our yard. So we tag team. Me and my son tag team. So when we're home, I'll grab a battery. I'll go out and I'll cut part of the grass, and then I'll put the battery on the charger. The other battery is already charged, and I don't know. I don't know, Jude. Not the answer to that is not one. Ryobi, yes. Well, he's at the beach, so now I have to do all the mowing. I don't have enough time in my day, guys. You don't understand. I am so stressed on time. I need more time. I got time coming, though. I do. I just do. It's so close. I'm so close. I'm trying so hard. But oh wait, no, that's not true either. I've been to the ER myself. So, yeah, I don't know, Jude. Not one, more than one. That's fine, though. You live and you learn, right?
You to have a seat, and Ms. Tarver's going to want to cross-examine you. Please sit down.
I have,
Sir, please sit down. She's going to cross-examine you at this time.
okay. I'm sorry.
It's okay. Ma'am?
I've got some things to mark. Should I? have-
Yeah, you can mark them. Yeah, you'll be respondent, and we just use numbers, so petitioner, I apologize, thank you. Yep.
I'm not an attorney, so if you could help me, let me know when I can respond.
Yes, sir. I would notify you, though, that you're here representing yourself, and that because you're here representing yourself, you're subject to the same. Sorry, my court reporter is going to want to type.
Yeah, I know the old idiom.
Hold on, I just need to notify him. Sir, you're here representing yourself pro se, which means without a lawyer.
It's just so annoying that he said my court reporter needs to type, so he had to wait for her to get to put the evidence in instead of Judy, because we're trying to figure out this woman's name.
So because of that, you're held to the same standard a lawyer is, right? So if you do a bad job today, you can't complain about that, right? You're representing yourself. All right?
I have no choice.
I understand, sir. Ma'am?
Sir, I'm going to show you what's been marked as Petitioner's Exhibit 1. Do you recognize that?
I don't know.
Does it have your name in the corner, sir?
It has my name in the corner.
Do you bank at Fifth Third Bank, or have you in the past?
I'm sorry?
Do you bank at Fifth Third Bank?
Yes, I do. To the extent that that's where my social security checks go.
Okay. Do you see, sir, that on January 10th, this indicates that you made a deposit in the amount of $294,365.98 into this account from your Edward Jones investment account. You see that?
I see what you pointed out to me.
Did you make that deposit, sir?
I don't know. Your Honor, I had
Ma'am, or sir, it's not the time for you to argue or talk to me. She's asking you questions. So if you can answer the question as best you can. If your answer is I don't know, then that's acceptable.
Judge, I move to admit petitioners.
can I speak to you or
No.
no?
You can ask, you can answer whether or not you object to that document being admitted into evidence.
Yes, I do.
What's your objection?
Because it does not, I have no memory of it. I have,
Give a business records
I
affidavit?
have,
And if I was ever in court, that should be a valid objection. If I have no memory of what you're talking about, ma'am, you cannot submit that as evidence.
memory loss.
Don't have.
That's your problem. It's hearsay.
I have memory loss from 2 crushed skull.
Was it your
Sir,
ex-wife?
I understand, but I need to keep this moving. I can't admit that anyway because it's hearsay and there's no business records affidavit. So I need to keep it, but I'm not going to admit it. Yeah. Even though he doesn't know what hearsay is or know how to object to it, I still can't consider evidence that wouldn't be admissible.
You can understand why I said that, because retrograde amnesia.
I wish you could understand why I said what I said, but I need you to hand that back to counsel so she can bring it up to me. I won't consider it during today's hearing. And then if you want to, we could reschedule maybe, and I still need it. Yeah, because I didn't admit it. But
Without,
yeah, you need to get business records affidavits and such like that. Yeah,
I didn't have them with me.
yeah.
without the understanding of the retrograde amnesia that I'm suffering from a neurologist and a psychiatrist.
Sir, please. Have you done holds on bank accounts as well?
No, because Mr. Pappas stays ahead of me in my discovery. So every time I send a non-party request, he's already moved the money to a different bank. And so then by the time I go to that bank with it, he's moved the money again.
Okay.
And so this is what's happening. And now there's funds in an Illinois bank, so they're not going to be responsive to any of my subpoenas unless something's domesticated over there. And I'd actually subpoenaed the bank statements from the Illinois bank where I believe $200,000 is sitting.
And you know what bank it is?
Yes, I do.
Why don't you just do a pro-sup on it?
Because it's Illinois, so they're not going to respond to it.
They are.
You think so?
Hey, Mr. Pappas, let's do a quick proceeding supplemental hearing, okay? Just to keep this proceeding supplemental going for the court. Do you own any real estate anywhere, sir?
I'm sorry?
Do you own any real estate anywhere in the world?
No.
Did the headphones stop working?
I'm having trouble with it.
Your headphones, sir. You need to put them up
Oof.
to your ears.
Do they not work anymore?
This just got bad for him, guys.
Go ahead, please.
Okay, do you own any real estate anywhere in the world, sir?
I can't, I'm not hearing. And I have this all the way turned up.
Judy, help. Judy, get up.
Okay, come up here. I don't know. You can take the whole thing away from him.
I have a feeling he's
Can you hear me now?
gonna hear Michael loud and clear right now.
What about now? Have a seat. All right, sir. Do you own any real estate anywhere in the world?
I'm sorry?
Do you own any real estate anywhere in the world?
No.
Okay.
He's faking.
Do you own any motor vehicles?
I have a lease vehicle.
Okay, so you don't own any vehicles.
No.
All right. Do you have any savings in any bank accounts?
Only the one where my social security check goes.
And what bank is that?
Fifth Third.
And your social security money is deposited there?
That's correct, sir.
Okay. Do you have any bank accounts in Illinois?
No.
All right. Do you have any other retirement accounts aside from this Edward Jones account?
No, sir. All I want to do is live.
Do you have any big ticket property items, any holdings with gold, anything of that nature?
No, those were embezzled by my wife.
Do you have any positions in the stock market whatsoever?
None.
Any futures positions?
None.
Okay.
Only one being the IRA.
Any other investment accounts of any kind?
None.
No stocks?
None.
No bonds?
None.
Okay. Any other questions you want to ask them?
Did you deposit money in 2025 in the First National Bank of Illinois?
Not to my recollection.
Okay, I'll continue this. I've got time a week from Thursday on the 16th. I don't know what your calendar looks like, counsel.
Are you talking to me or
What?
the,
In the afternoon, Judge, or the morning?
Either one.
I could do the morning.
I could be ready by 9:30.
Your Honor,
I don't
I
think that works.
can't because
Mr.
I'm,
Pappas, do you have any availability next Thursday, the 16th?
no,
What's your situation?
because I'm going to Sloan Kettering for further cancer treatment.
How long have you had that appointment?
The appointment was just made a week or two ago.
Okay, and your appointment's on the
through
16th?
a urologist.
Your appointment's on the 16th?
I don't remember if that's the exact day, no.
Sir, how can you say you're unavailable for something because you have an appointment and yet not know when the appointment's actually scheduled?
Because they want me at the spur of the moment. They only have so many openings.
Okay, well, you tell them that the 9:30 opening on July 16th is unavailable because you have to be in court. All right? And I'll see you back at 9:30 a.m. on July the 16th. You're ordered to appear. And if you don't appear, I'll issue a bench warrant for your arrest. Okay? We're adjourned.
Is that,
Thank you, Your Honor.
Yes. Mr. Elwood, you got a couple cases. Giovanna Ricciardi, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Giovanna Riccardi, cause number 64D01-2602F61886. Defendant appears in court in person and by counsel, Mr. Ken Elwood, State of Indiana by Gary Gurman.
Yes, sir.
Judge, I met with Mr. Gurman last week. We're waiting for the state police labs to show us the results of this substance. So if I could get a new date,
How far out you think you need?
45 days, 60?
I would say 45 to 60, Your Honor, with the lab being a little backed up these days.
I'm happy to go to September 11th if the state has no objection.
No objection, Your Honor.
All right. On defense motion, we'll set your case over to September the 11th at 10 a.m. in order to appear back here September the 11th at 10. Okay?
Thank you, Judge.
The latest charge to the defendant. We're adjourned.
Yep, take care. You too.
Mr. Lance Washington, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Lance Washington. The two cause numbers, 64D01-2412F612572, 64D01-2510CM11448. Defendant appears in court in person and with counsel, Mr. Ken Elwood, State of Indiana by Gary Gurman.
Yes, sir.
Judge, we have a plea offer from the state. It requires payment of restitution prior to entry of it. My client tells me that he can have that paid by the end of August, so perhaps that same 9/11 date.
Any objection, state?
No objection, Your Honor, but I believe there's a trial date
There is.
of September 1st.
Yep.
So that would have to be stricken.
I've got a trial date September 24th.
And I have one for September 1st.
I think both cases are set for trial. One of them set on September 1st and one of them set on September
Yep.
24th.
I see that now. We could.
So I'm not striking any trial dates. I'll see you back on August 28th. Right?
With the trial date on September 1st?
Yeah. We're gonna get it done?
I agree.
We're gonna get it done by that time, Mr.
Yes,
Watson?
sir. We're gonna
Okay,
get it
by August
done.
28th? Okay,
How much money are we talking about?
700 change.
Okay. Can you afford to come up with it that quickly? Okay. Let me see something. So I've got another jury trial anyway, that same day. So summonses are gonna have to go out anyway.
I'll get my motions in limine on file.
All right. I'll look for them. See you back here August 28th, 9 a.m. We're adjourned.
Thank you, Judge.
Yes, sir.
Have a good week.
You too. Mr. Worthley? For Derek Powell, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Derek Powell, cause number 64D01-2604F62333. Defendant appears in court in person by video conferencing and secure with counsel, Mr. Mark Worthley. State of Indiana by Gary Garman.
Mr. Powell, do you have us okay?
Yes, sir.
Thank you. Mr. Worthley, how can I help?
Judge, we are asking for a brief continuance. We've been in touch with the state of Indiana, and
Do you think he's sitting in a bed? Because that's a weird back for a sofa. I don't think anything in the entire world could make me go to court in my bed. Nothing. Nothing in the world could make me turn on my camera for court if I was in my bedroom.
I've made a proposal, and I'm waiting for them to react to that proposal. So on my motion, I would just ask for an additional 30 days, and hopefully that we can have it wrapped up.
Okay, state, any objection to August 28th on this?
No objection.
August 28th work for you?
Yes, sir.
I was asking your lawyer, sir, but
Oh, I'm sorry.
At 11, it would work.
that's fine.
Okay.
All right. So on defense motion, we'll set your case over to August 28th at 11 a.m. Where are you located, Mr. Powell?
Iowa.
Iowa, sir.
Okay, do you need him present for it?
No.
Pardon me?
I would ask for him to be permitted to be by Zoom on August 28th as well.
Okay, if you're going to try to do a plea, make sure you get a waiver.
Okay.
All right. Yeah, Mr. Powell, you can appear by Zoom for the August 28th hearing as well. All right.
Thank you, sir. Thank you, sir.
Good day, sir. Delays charged to the defendant. We're adjourned.
That's one thing I miss about relationships. V. No one tells me my glasses are dirty. It's hard to tell when they're on your face. But no one says, hey, clean your glasses. So I constantly just clean my glasses for no reason. I just grab them and clean them and clean them. Because I don't want anybody to see my glasses being all dirty and I can't tell. My eyesight is terrible. It's unbelievably bad.
Travis Williams, state, would you please set a record?
Yes, Your Honor, thank you. This is State of Indiana versus Travis Williams. The cause number is 64D01-2509F6-10502. Defendant appears in court.
I don't see him.
He is not here, Judge. Sorry, I don't want to.
Let me finish. The defendant fails to appear. He is here with counsel, Mr. Mark Worthley. State of Indiana by Gary Gurman.
Yes, Judge. We have a pretrial diversion agreement signed by the defendant. However, there's a minor scrivener's error that needs to be corrected, and just spoke with Mr. Gurman about that. I believe that okay. Oh, okay.
Oh, I wish I had OCD sometimes. I'm not... Look, I know OCD is terrible to live with. I get it. But I need something in my brain that says, get up and get those dishes done. You know what I mean? I wish I had something motivating me to get up and get the dishes done.
So I just need to get his signature on this updated agreement, and I think so I would ask for a continuance, and then just a bit of direction from the court. Is this something that I'm permitted to submit e-filing? Okay, and so that's what I would do then.
Is there a review date in there?
Probably not. I think he needs to get that from Judy.
Okay, I will coordinate with court staff on getting the review date.
You do it in 2 weeks?
Yes. That should be no problem.
All right. So I'll set the case over to July 31st at
Hi, Terry.
Okay.
10?
July 31st at 10.
I mean, I don't expect you to hold it, so you could vacate it if you need to.
That's fantastic.
Okay. July 31st at 10 a.m. We're adjourned.
All right, thank you.
Thank you. Is that all clear to you?
Yeah.
Okay. Is that different, like, than other people do it? We're trying to make it as easy as humanly possible.
You know what? To be honest, every single court does it differently.
Okay. I don't know if there's an easier way, but it seems to me like that's the easiest way we could.
E-filing it is the easiest way.
I'll look for it then.
Okay, thank you.
Yeah.
Thank you.
Mr. Ostrowski's got David Keaton. State, would you please set a record?
Yes, State of Indiana versus David Keaton, cause number 64D012510.
Conveniently, I have dishes to do over and over all day long. I just have them. They just materialize all day.
F611036. Defendant appears in court in person with counsel, Mr. Michael Trajewski, State of Indiana by Gary Gurman.
Yes, sir.
Judge,
You know what's weird? And it's the same with my children as well. When I go to work, I go above and beyond. Like, I just scrub the top of a refrigerator. No other servers scrub the top of a refrigerator. My children also, when they go to work, they go above and beyond. They do their job, and then they do other things that no one else does. They just do it all day. But when the three of us get home, there could be a sock on the living room floor for 7 months. The sock isn't hurting anything. It's just a sock. But like, unless one of us has to wear the sock, we just don't overperform at home. You know what I mean? I wish one of us would slack off at work and be an overperformer at home. That would be lovely.
I just recently entered in this case, and I've had a discussion with Mr. Keaton. He's unable to afford my services and wants me to withdraw at this point.
Well, that was quick. Is that it, Mr. Keaton?
Yes.
You can't afford Mr. Ostrowski's attorney's fees? How'd you get him involved to begin with?
Well,
He had a payment plan, Judge, where I let him make payments as it went along, and he was only able to make the first payment, and he can't make any other payments.
Okay. Mr. Keaton, can you take the mic and direct it towards your face? Please raise your hand to be sworn. Do you swear affirm under penalty of perjury to tell the whole truth and nothing but the truth?
yes,
Okay, thanks. Are you asking for appointment of the public defender?
yes.
All right. And what are you doing for work?
Right now, I'm working at Comfort Inn in Hebron, Indiana, right off of 65.
How much do you earn?
I only make $11 an hour.
Okay, how many hours a week are you working?
Holy
work-
moly. $11 an hour? How in the world do you live on $11 an hour?
6 days.
That's not hours.
Oh, probably like 7 hours.
A week?
7 hours.
No,
How many hours a week do you work, sir?
probably about 37, 38.
Okay. And are your checks just under 300?
Yeah,
Okay. Is that the only form of income you have at this time?
yes, that's correct.
All right. Are you renting or buying your home?
I'm renting.
And do you still have somebody helping with bills?
No, it's just myself.
Okay. How much is your rent?
1100.
And you're
Oh
responsible
my
for that rent on your
gosh.
own?
Yes, I'm actually behind.
Do you have
Yeah.
any form of public assistance?
No, he won't take no public assistance or anything like that.
Who won't?
Minimum wage in Pennsylvania is $7.25, but I know I'm not the lowest. There's no possible way to live on minimum wage. None. There's no way you could rent. I don't. It's $11 an hour is shockingly low to me. I don't even understand how he lives.
The landlord?
No. Have you applied for public assistance?
No,
like
I have
food
not.
Stamps or anything?
No,
Okay. Are you going to?
I plan on it.
All right. I mean, you're definitely indigent. You qualify for services of the public defender. I'll note the withdrawal of Mr. Ostrowski from the case, appoint the Porter County Public Defender Service to represent you. Appreciate you coming through.
Me too, Kelly. I go in to work when I was in Lancaster and after I moved, at least an hour early every day, sometimes two. And I just get extra stuff done. Not on the clock. I'm not allowed to punch in, but I do it. I've done it every day since I started. I mean, a couple days I went in on time, but yeah, every day. I mean, every day I work, I go in way before anybody else is even out of bed.
Got you. Well, there's no hearing set at this time. I'll set you over to August the 21st at 9 a.m. Your order to appear back here August 21st at 9.
Okay, thank you.
Okay?
Thank you, Judge.
Thank you. We're adjourned. Yeah, we're going to give you a note. Delays charged to the defendant as well. Joshua Arndt, state, would you please set a record?
This will be State of Indiana versus Joshua Arndt, 64 D01 2402 F6 2118. Defendant fails to appear. State is represented by Deputy Prosecutor Hammer. We were set today as a
My first job was Roy Rogers, and I made $2.85 an hour, and there was no tips. But I remember I made $2.85 an hour, and I saved up $1,000 for real quick. I mean, I was a teenager. I was 15, I think, when I started there, and I saved it up so quick, and then me and my girlfriend, she got a car, and once she got a car, we were able to go places. Oh man, we went through that $1,000 so fast when she first got her car.
and admit deny on a petition for revocation.
Good morning, Ms. Gary. Did you have service on Mr. Arndt?
I did not. The letter came back, but we had talked on the phone and he was well aware of the hearing today.
You gave him notice, a verbal notice of the hearing today?
I did, and
When was that?
it was our last phone call, which was April 13th.
State?
State would be requesting a bench warrant to issue.
We will issue the bench warrant for the failure to appear and catch up with Mr. Arndt when we have him in custody.
Well, could I ask the court something?
Possibly, yeah.
Okay. Your Honor, this is a matter of my client not paying his fees.
Okay.
We had an administrative hearing in our office. We allowed him an extra 3 months to pay it. He's been working off and on at fast food restaurants. I was just wondering if the court would be so inclined to just let me enter judgment liens, release him unsat, and then this case can be closed.
Any problem, State?
No, I don't have an issue with that.
We'll follow the recommendation of the probation department, enter judgment liens for the remaining fines, fees, and costs, and show him unsatisfactorily discharged from probation.
Thank you, Your
Okay.
Honor.
Yeah,
Yes.
thank you.
All right, my alarm's going off, so that means I have to get my daughter to work. There was 6 more minutes left in this docket, but we're just going to have to stop it here. But don't worry, nothing exciting happened in the last 6 minutes. It was probably just same with the people who didn't show up, getting some bench warrants. This was rock steady internet for 1 hour and 54 minutes. And that's fan-freaking-tastic. I'm so pleased. I'm so happy. It's just such a relief because I didn't know what to do next. I mean, I didn't know what I was going to do, guys. Thank you so much for coming out. I'll see you again in 22 hours. Please be safe. It's Monday. I know it's Monday. Or is it Tuesday? Nope, it's Monday. So, treat Monday extra special for everybody else because everybody else does not want to go to work today. So they're all stressed and they're all grumpy. So maybe you know what you should do? You can get a bunch of carnations for $3 at the flower shop. Or steal them from someone's yard. Don't do that. And you should just walk into 7 random offices today and give whoever you see first in there a carnation and leave. And that'll make their Monday a little bit better. Cost you a couple bucks. Well, wait, no, not if you drive there, because gas is so freaking expensive. So, forget it. Don't do that. Keep your $17 a gallon. That's the joke. It's not $17 a gallon yet, guys, from International, who think that I'm telling the truth when I'm lying. But I don't even want anybody from Australia to tell me how much gas is there, although I hear it went back down. I know it was ridiculous. It was like $11 a liter or something like that. Terry, thank you for the floating heart. I love it. All right, guys. Hey, Jude. Jude, that's Jude coming in with a win. Go to a funeral home, dig through their trash, get the flowers. When you pass these out, do not A, tell the person you're giving them to it was a funeral home. Do not B, tell them you went into the trash can to get them and see that you took them without paying. Although if the trash is at the corner, at the street, it's okay to take. My mom taught me that. She is a fantastic dumpster diver. My mom and my sister, man, that's their Friday night excitement. They go dumpster diving. I can't do that. I cannot. Although that chicken on the road, that one, I wanted to take that, but I didn't take that because that would be stealing. I just want a chicken. All right. I hope you guys have a great day. Love y'all. I'll see you again real soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't. Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed